Nancy Pelosi was Speaker of the House of Representatives when Obamacare was coming up, 2,700 pages, and she said famously, "We've got to pass it so we can read and find out what it says." Can you believe that? But that's exactly it. Nobody knew. It had so many twists and turns. Nobody had a clue. And many of us thought that it was unconstitutional. But guess what? John Roberts of the Supreme Court pulled a sleight of hand and said, well, it's really a tax. And the Congress has the power to tax. This isn't a burden on commerce. It isn't the interstate commerce clause that's involved. It is taxation. And so if Obamacare is constitutional, what happens next? Well, that's not the final word. Even now, Obamacare faces a growing number of legal challenges, and some of them may just lead to its downfall. John Jessup has this interesting story from Washington.
While states scramble to determine just how to implement the Affordable Care Act, or Obamacare, opponents are still fighting the law in the courts.
And there are going to be legal challenges that will be continuing for quite some time.
The legal argument gaining the most steam is the challenge to the contraception mandate. Religious business owners and faith-based organizations argue the mandate violates their religious beliefs by forcing them to cover the morning after pill and similar drugs in their insurance plans.
The case is about whether the government can say, we're going to force you to violate your faith or pay a fine. Today it's contraceptives and abortion-causing drugs. Tomorrow, what else is it going to be?
Another challenge takes aim at a 15-member independent board created to keep Medicare costs in check. Opponents argue it violates the Constitution's separation of powers. Yet another challenge could put the fate of the entire law in jeopardy.
Yes, we will! Yes, we will!
Last June, the Supreme Court ruled that the individual mandate is a tax. The Constitution requires all taxing measures start in the House. But opponents argue the final version of the bill that became law actually originated in the Senate.
If that lawsuit succeeds, then the Obamacare bill was passed in an unconstitutional manner and it would be stricken.
Still, the argument that appears to be on the fast track is the challenge to the contraception mandate, which opponents call a threat to religious liberty. Lawyers representing religious organizations will argue that case in front of a federal court this spring, and if they're successful, Obamacare could land before the High Court again before the end of the year. John Jessup, CBN News, the Supreme Court.
This makes you sick. We're going to be fighting that thing for years and years and years, and it'll be more and more and more challenges. Maybe they'll chip away at it. Well, with us now, with more on the future of Obamacare, is Jay Sekulow of the American Center for Law and Justice. Jay, Hobby Lobby has said that that individual mandate violates their religious freedom, and they face incredible taxes and penalties. What do you think? Are they going to win or lose?
Well, Pat, let me give you the best analysis. We have 3 cases right now involving private employers, large employers, not as large as Hobby Lobby, but big companies, multinational companies. And we've won all 3 of our cases, including 2 Court of Appeals decisions, one out of the 7th and one out of the 8th Circuit, both confirming an injunction to be put in place, not allowing that HHS mandate to be put forward. Hobby Lobby actually is the outlier right now. Most of the court cases, certainly we're 3 for 3 on our challenges, but most of the court cases, the courts of appeals, and even the district court judges have, in fact, said that the HHS mandate should be enjoined as far as enforcement goes when there's a legitimate free exercise challenge. So, you know, Hobby Lobby's just, got a bad panel, and that happens in Court of Appeals cases. When I say a bad panel, judges that were not hospitable to their argument, or that were not inclined to view their argument as one protecting the free exercise clause. But I think that's the outlier. I'm optimistic. I think it's going to be a real challenge. Ultimately, as the reports indicate, as you just said, it's going to go to the Supreme Court of the United States. But right now, we're battling 1,000. We're 3 for 3, and I'm about to file 2 more suits now.
All right, what is the central legal premise that you're working on to get those things reversed?
You know, Pat, it's really straightforward. It's something you and I have talked about for years, is that the idea that the government would put something in place that mandates or requires that you violate your conscience would make the founders to spin their heads. They wouldn't believe that the government would come in and demand you violate your sincerely held religious beliefs. So the claim is both on the Constitution and their statutory claims as well. Interestingly, I think the real challenge here is going to be, and you just mentioned this, Hobby Lobby's facing $1.3 million a day in fines. The government, I think if it was smart, would abate those fines right now, or at least not abate enforcement, so that they don't go after those fines while these cases are finally adjudicated and ultimately at the Supreme Court, rather than burdening Hobby Lobby with this extraordinary fine. But you know, Pat, you couple the situation with the HHS mandate, and then most of the states are not going to be able to do the state exchanges that are required under Obamacare. You've got, you mentioned the tax on medical devices, which now liberal members of the Senate have said don't enforce that tax. I mean, it could be death by 1,000 cuts here, the way this is going. But we've got a real challenge ahead. I don't want to belittle it in any situation. It's a significant challenge we have. But so far, we're 3 for 3 in these HHS cases.
What about this concept that a tax measure needs to start in the House of Representatives, that this bill started in the Senate? Is there any validity in that claim?
You know, I think there is. Chief Justice Roberts came up with this tax theory, which I think was a stretch at best, to be quite honest. I mean, I completely disagree with that analysis. And the government argued, and certainly the president said this was not a tax until they got to the Supreme Court of the United States and realized their Commerce Clause argument was weak. But if it was, in fact, a tax, and the Supreme Court has said it is a tax, well, then it's supposed to originate in the House of Representatives. It did not. It originated in the United States Senate. There are challenges going on with that. Will they try to find exceptions? Will they say, well, the House codified the same language? I don't know. But the reality is, I think all of these challenges are important. They all have merit. And sometimes it takes multiple challenges to get a significant piece of legislation overturned. And I certainly don't want to lose hope. Like I said, we're winning on the HHS mandate cases. And we're looking at these taxing authority cases as well.
What was going on in John Roberts' mind? He's a conservative. Was he trying to preserve the integrity of the court against challenges in an election year? What do you think it was?
Well, no, I think here's what it got. I think, what happened was under the Commerce Clause, this was a situation where, and the opinion was great on the Commerce Clause, that government did not have the authority to regulate under the Commerce Clause the healthcare industry. That was a great statement from the Chief Justice of the United States and a great statement from the court. The problem was that the Chief Justice just came up with this taxing authority issue. The problem with that, Pat, is quite simple. I'm a tax lawyer by training. You know that. If it was a tax, and I worked for Treasury, well, if it was a tax, then the case shouldn't have even been in the Supreme Court in the first place, because the Anti-Injunction Act says that a tax cannot be challenged until it's actually enforced. So then they should have dismissed all the cases and let us start it all over again. But that's not what they did. They find it a tax for the purposes of congressional authority, but not a tax for the purposes of the Anti-Injunction Act. A year later, I still don't buy it, or 7 months later, I still don't buy it.
But Jay,
it doesn't work.
The death by 1,000 cuts, it looks like it'll fall sooner or later. That's your prognosis?
Well, I think they're having the economics of it. I mean, you've talked about this a lot.
Oh,
the economics of the Affordable Care Act are just outrageous. I mean, you've got between the mandates and these state exchanges that can't get off the ground. I mean, I think, was it 15 or 16 states have said they think they can do exchanges. The other 35 cannot, which means the federal government's going to have to. Well, we know what that's going to be, a disaster. So, I mean, the implementation of Obamacare could cause it to fall on its own, coupled with the legal challenges. So, we've got to keep fighting on this. I think this is such a redo of our healthcare system that we'll be regretting it for generations to come if we don't get it overturned.
Well, my brother, thank you for the work you're doing. Keep hammering away. It's an obnoxious piece of legislation. All right, Jay Sekulow, the American Center for Law and Justice, fighting for your freedom and liberty.